Members, we have formed a quorum. I now call the meeting to order. This is a meeting of the Constitutional Affairs Panel. Please invite the officials to join us now. Item number 1 on the agenda, information papers issued since the last meeting. There are 2. They are from the same organization. That is in relation to the voting arrangements for persons with visual impairment. Both are from the Hong Kong Blind Union. Item 2. Items for discussion at the next meeting. Please ask the Undersecretary to be seated first. We have Mr. Lau Kong, Undersecretary, Mr. Gordon Leung, Deputy Secretary for Constitutional and Main Affairs, and Mr. Lee Pak-hong, CEO, REO, and also Ms. Candy Ma, PEO from REO. Undersecretary, what do we have for the next meeting? We have proposed 2 items for the next meeting. First one, the provisional proposals for the geographical constituency election for electoral election in 2016, and second, a briefing by the chairman of the Equal Opportunities Commission. And previously, some members asked for the information on the creation of a new post of CEO in the EOC. So 2 items. Members? 2 items, GC election for 2016 electoral elections, provisional proposals. Second, briefing by EOC chairman. If there are no objections, then I would have these 2 items for the next meeting. Next item, proposed guidelines issued by the Electoral Affairs Commission on election-related activities in respect of the District Council election. There are 3 relevant papers: CB 2-1409-14-15, proposed guidelines on election-related activities in respect of DC election issued by EAC. Second paper, CB 21459-14-15, and Min's paper on proposed guidelines issued by EAC on election-related activities in respect of DC election. Third paper, CB 21459-14-15, 04, background brief on guidelines issued by EAC on election-related activities in respect of DC election, prepared by the Legislative Council Secretariat. Shall we have a briefing first before we put questions to the Undersecretary? Or you want? Okay, you want to ask questions. Okay, let's have the introduction first. For the next DC election to be held in November this year, the EAC has proposed some guidelines on election-related activities. As these are drafted by the EAC, perhaps I should defer to Mr. Lee for an introduction of the subject. Mr. Lee Pak-hong? Or actually, every time before a DC election, the EAC would issue guidelines to regulate the election-related activities. But the next DC election will be held on the 22nd of November 2015. The EAC has updated the guidelines for DC elections for public consultation. The guidelines set out the code of conduct and the relevant guidelines for relevant parties involved in the DC elections. The consultation period will last for the 30 days from the 5th of May to the 3rd of June this year. Members of the public are welcome to submit their views on the proposed guidelines to the EAC in writing, or they may attend the public forum to be held on the 19th of May to present their views. Well, this time the guidelines have been updated to take into account the experience since the last DC elections. We also propose something to improve the way the guidelines are expressed so as to clarify them and to facilitate compliance. Relevant amendments have been set out in the annex, and further information has been provided through the proposed additions and amendments. For example, Chapter 2, revising the key days, and also set out clearly the REO's checking measures to ensure the accuracy of electors' particulars in the registers, and highlighting that it is an offense to knowingly or recklessly give false or misleading information for voter registration. And in Chapter 10, the guidelines elaborate the application of the fair and equal treatment principle in producing and conducting election-related programs by licensed broadcasters, and also media are reminded that their newspapers or references made in the publications should not give unfair publicity to any particular candidate or candidates. Otherwise, it may be in violation of the relevant guidelines and rules on advertisement and advantage. And in Chapter 8, the guidelines serves to remind candidates that if they wish to collect information, personal data for their own campaign, they should make sure that the data collected will be in line with the PDPO. And we also set out some appropriate administration procedures in approving application for the conduct of exit polls, so that, that they will not affect the fairness of election. And also there are amendments to remind candidates of the need to apportion expenses if some funds are for dedicated purposes. And also candidates should propose a set of good practice. Candidates and supporters, when giving their names, can consent to support certain candidates, and they mentioned that official office titles, there should be certain guidelines that they should follow. We are going to consult the public first, and then the guidelines will be finalized at the end of August. That's by way of my introduction. We are happy to take questions. We have the following members who wish to ask questions. I'll call out the names. Mr. Jeffrey Lam, Mr. Chen Kam-nam, Mr. John Fong, Alice Mack, Leung Yu Chung, Starry Lee, Sin Chung Kai, Yip Kok Kim, Christopher Chung. Your name has been called out. I would like to have my turn sooner. All right? 4 minutes for each member. Mr. Jeffrey Lam. I want to ask 2 questions about civil servants involved in election campaigns. The government has no in principle objection to civil servants supporting certain candidates in their campaigns. So what is meant by no in principle objection? If a civil servant is an active unionist or is an active member of a social organization, would he or she be restricted in participating in such electioneering activities? And it said that directorate officers, AOs, and IOs should not openly support any candidate. But if they are if they express certain opinion after office hours in some social media with regard to the platform or manifestos of certain candidates, would it be against the law? Or is it the case that once the name of a candidate is mentioned is against the law?
Mr. Lee, Chairman, with regard to civil servants taking part in electoral campaigns, you can see the details in Chapter 8. Now, several types of civil servants are not allowed to take part in such campaigns. Now, for example, directorate grade officers, AOs, IOs, and police officers, they are not allowed to take part in any election-related activities. As for other civil servants, they are allowed to do so unless they are working for this particular election in their official capacity. And when they take part in the electoral campaigns, those activities should not constitute conflicts with their duties, and they should not wear government uniforms when they do so. For any civil servant, he should be able to enjoy the freedom of speech. But for the four grades of civil servants that I mentioned just now, because of the nature of their work is basically sensitive, so that's why they should refrain from taking part in electioneering. Otherwise, people may query as to whether there's a direct conflict of interest with their official duties. If they talk to their friends, it is part of the freedom of speech, so they are allowed to do so. However, if they openly take part in election-related activities or speak on such activities, then they are violating the relevant civil service rules. Now, as I asked just now, I also mentioned social media. You said that when they talk to friends, it's okay. But for social media, they are also talking to friends, or they're just expressing their own views. So can you answer me clearly as to what this would induce? Mr. Lee, now these are the rules set out by the Civil Services Bureau, and if civil servants have questions, they can ask the CSB. But for social media, it's an open platform. And if people know that you are a senior civil servant and you are working in a certain capacity, then people may query as to whether you're actually assisting someone in his election campaign. So the relevant rules may be violated. Mr. Chen Kam-lam? Chairman, I would want to understand more. Now, for DC elections or other elections, there are some areas that are still quite ambiguous. For example, election advertisements and the application for it. In a constituency, usually places are allocated for the display of election advertisements or EAs. However, the candidates can also apply for other EA places. So there are ambiguous areas. So when a candidate makes an application, the relevant government department would say that I have to wait for the other candidates' applications first so that I can make a fair allocation. That is reasonable. However, as you can apply for extra space, then it would be quite confusing because you have to wait for other candidates. But if the other candidates do not make such an application, what should be done? So I think this point has to be clarified. And also for election expenses. In the past, we have seen some cases in which candidates would overspend, or they might have omitted the report of certain expenses. But eventually, the court doesn't didn't rule that there was a violation. So this may constitute unfair treatment. So how should we abide by the relevant requirements? I think there are also areas that are unclear. And also in the past, some candidates might have titles. For example, they are lawyers. They can say they are lawyers, they're professionals, or they are professors or assistant professors. But some of them didn't make such titles clear. So voters may be misled to believe that they are very senior professionals and thus voted for them. So I think there's no clear guidelines as to what titles can be used. Mr. Lee? There are 3 questions. First, about the display areas of EAs. Now for general elections and ordinary elections, the places for EAs are to be coordinated by the REO. So on government land, such places are to be administered centrally by the REO. So the candidates cannot apply for extra areas or spaces afterwards. So we already have an arrangement, that is, for the housing department and the lands department, they must let the REO know what places are available for EAs, and the REO would coordinate centrally. If candidates identify places in private areas, for example, private housing estates, and they would make application to the property managers of such estates. But for the distribution of such spaces, the manner must be fair. You cannot give it to one candidate but not the other. And also for election expenses, we understand that for each candidate, he has to file a report on his election expenses. We have to monitor the total expenditure and try to find out whether a certain candidate has exceeded his limits. So he also has to produce evidence and give us a list of all the expenditures. We will look at all the relevant documents, and if we find that there's an omission, we will refer the case to the ICAC. Now there is an arrangement. If it's just a careless omission, there is a procedure in place, and the candidate can rectify his mistake. After the investigation of the ICAC, if there's evidence, there will be prosecution. But if there's a lack of confidence, the ICAC will remind the candidate that what he should not do in the future. As for titles, well, Mr. Chen asked about titles. If some candidates make use of the titles in the EAs, and if the title is not real, and this may mislead voters, so he might have violated the ECICO. If a complaint is received in this regard, the case would also be referred to the ICAC to follow up. Next, Ms. Ray Chan. Chairman, I would like to ask about exit poll. And actually, there are just a few sentences about it. That is, the result would not be announced too early, because you don't want the poll results to affect voters' choice. In the past, we knew that some political organizations might make use of such exit polls, or they may even fake the exit polls, so that they can manipulate the votings. So now you have some guidelines for exit polls. Do you think these people have already violated your relevant regulations? And if they make use of such exit polls to manipulate voting, would that be regarded as one of their election expenses? Now, according to our guidelines, if we approve an exit poll, then the relevant people would have to sign an agreement that is before the close of the polling, they would not make public the exit poll results, and they would not guess the polling result. And they should also undertake that such polling results would not be given to any candidates or any organization or person which has relations with candidates. So there are a number of restrictions. We do not want the exit polls to give people a negative impression. That is, such exit polls are being used for or against certain candidates. We do not want the exit polls to have a negative impact on elections. And there are some people who cannot do exit polls, for example, candidates. We will not approve that. And also the political parties that the candidates belong to. And if anyone who has publicly announced that he is in support of a certain candidate, then he would not be approved to do exit poll. And if you are approved to do exit poll, the responsible people cannot belong to the organizations that I mentioned just now. We hope that by doing all this, people would not have such a negative impression about exit polls. Yes, the exit poll results will not be given to political parties, but what if they are given to a third party and eventually the exit poll result ends up in the hands of a political party? What will happen? And who should shoulder the responsibility? Mr. Lee? I don't think I should comment on any individual cases, but in the undertaking, it is stated very clearly that the exit poll result should not be given to certain people. But what if I lose the exit poll results? So if the exit poll result eventually ends up in the hands of a certain organization and is used to affect the polling results, then of course the person who lost the exit poll result would have to shoulder certain responsibility because he has signed an undertaking. We will definitely follow up on cases like this. Next, Ms. Alice Mack. Chairman. Chapter 2, Registration of Electors and Voting System. The government has been encouraging people to register, and also they are checking the voter registrations, and the government says that it will send out 1.6 million letters to registered voters. So how do you find out those 1.6 million voters? Do you select them at random, and you are sending registered mails? But what if that person's not at home? If he misses the registered letter, what will happen? You also want the registered voter to show you address verifications. So if you suspect if a person is an eligible register, you just ask him 2 questions, A and B. And then if you send him a letter, you need him to prove that he actually lives at that address. That's are you really encouraging people to register? And for Chapter 7 is election advertisements. You are saying that you will be sending e-advertisements, but the candidates would have to do a lot of reporting. However, now people are using Facebook and Instagram. There are a lot of social media nowadays. If I post, I have registered with you, and then I post on my social media, but then what if other people share it? That person, he has not obtained my consent, and he's now distributing my EA. So does that person have to bear the responsibility? Now for voter registration, now in each cycle, we would carry out verification work. Ever since 2011 DC election, people have been very concerned about the accuracy of registered details. So each year we will do a checking, but this year is the election year, so we will be making more efforts and the scope will be wider. Just now, Ms. Alice Mack mentioned 1.6 million mails. So I'll tell you more about our operation.
There are three categories. First, we will check with the housing society and housing authority over particulars of voters, because 40% of the voters live in public housing estates. Second, we do some random checks. All 3.5 million voters will be selected under a random basis for checking. And then there are targeted approach. Our colleagues would check if the address is incomplete or is suspicious, say it's in a commercial building, it's in a factory. These will be taken out for checking. We also cross-check with information from the Hong Kong Housing Society. If a building has been demolished and yet some voters are using that as an address, we'll do the checking. So 1.6 million voters will be checked. Not all of them will be sent letters. If we check that the address is correct, there will be no further follow-up action to check the registration. But if the voter responds to our queries and everything is fine, then the registration will be kept. But if there's something untoward, then we would invoke the statutory checking process. We send out a letter. In this cycle, we are still in the middle of the checking cycle. We started to issue the checking letters at the end of last month. We expect that we're going to send out some 80,000 checking letters or inquiry letters. And I would like to take this opportunity to appeal to all voters that if they receive such letters, they should immediately respond. And these letters have to be sent as registered mail according to the law. The letters are easy to respond. It's simple. What it takes is to put a tick in the form and send it back to us. This is for the purpose checking the main residence of the voter. The voter is only asked to tick one of the boxes and send it back to us. And once this is confirmed, the registration will be kept. In some cases, they will have to provide proof. For example, the building has been demolished, or if the name is not that of any tenants of housing authority, public housing estates, or of that particular unit, then we ask for proof. The voter has the responsibility to provide accurate information and to update voters' registration information timely. If the comprehensive or the required information is provided to us, the registration will be kept. As for the electronic EA, Well, since the last amendment exercise, well, we have been allowing a central electronic platform to be kept to comply with the law. For example, the EA sent electronically, which can be updated instantly. And sometimes it's provided in the form of a hyperlink, and then the relevant requirements will be met. But if someone resent the information to someone else, then it would may constitute another EA, and it may run the risk of certain provisions in the ECICO, and that is EAs will be sent without the consent of the candidate. Well, that's very detailed, a detailed explanation from Mr. Lee. Next, we have Mr. Stephen Ho. What about registered mail? What if the registered mail is not collected or is not received? Well, there are many things that are unreasonable in your reply. How do you randomly select voters for checking? You don't understand the situation on the ground. And some fishermen might have gone away for their fishing operations, and once they returned, they found that their registration had been cancelled. He said that if the address is incomplete, or it's for commercial purposes, or the building has been demolished, you ask for residential proof. Do you have other causes whereby you would ask for address proof? We'll check with the buildings department. If a building has been demolished, then we ask the voter to produce residential proof. And we also check with the information of the housing department. Well, I'm not talking about those who are living in public housing estates. The question is that I confirm that this is my main residence, and I hereby submit my proof. Or second, I have moved to another address. So in this case that I've quoted, the address is not incomplete, the building is not demolished, but still you want the person receiving this letter to produce proof of residential address. Can you provide a response? Mr. Lee, I don't think I should comment on individual cases. If we ask for proof of residential address, there must be some reason why we have doubts. Then we want to know whether the address is the main residential address of the voter. First, if we have checked with the housing department, or if the building has been demolished, or if a certain mail was previously returned undelivered. So that may constitute some of the reasons why we would have doubts whether the address is the residential address of the said voter. What about those living in private buildings? How many of them? How much will be accounted for those living in residential? Among the 1.6 million, 1.4 are living in HA or housing society estates. The rest lives in other buildings. And out of the 100,000, how many of them have been asked to produce proof of residential address? Well, we don't have such a breakdown. It's not dependent on where they live, where the voter lives. We ask the questions because we have doubts about whether the address is the residential address of the voter. Well, this is a nuisance for voters. Some would rather give up their voter registration instead of making a declaration. This is a lousy idea. There's someone working in an office concocted. Oh, we have 2 hours for the DC election. Why don't we just have one item? The first one is the proposed guidelines. They have amended the laws, and every term, for every election, they set up some guidelines for reference. They have certain rules for the media and for the candidates to comply with. So this is not meaningful as a subject for consultation, because you are going to do what you are going to do. And now EO is the executive arm of the EAC, and that's why we have the Undersecretary. And then the next item, we'll be talking about practical arrangement for the DC election, the same issues, and we'll be repeating the questions. But I just want to raise some issues to provoke thinking. On EA, you do not cover those using the internet as a media. According to ECICO, to facilitate or to prevent one candidate or more than one candidate to win the election, and you release certain information, then it's an EA. So you can issue an EA to facilitate the successful election of a candidate or to prevent his successful election. That's an EA. We are using smartphones, and people are using social media such as Facebook for the EA purpose. Social media will be used, and then there will be dedicated page, dedicated groups for the election. Would those be regarded as EAs? They were using the dedicated page to publicize a candidate, but the page may not necessarily be set up by the candidate, and they can use aliases. There can be other people. There can be people using more than one name. These pages, these groups might be doing positive or negative publicity for the candidate. Well, we have encountered many such instances in my election. And there are also hyperlinks provided in the central platform offered by the REA. Well, what about apportioning the expenses? So sometimes we would just make a report, the expenses are not high, but what about those EAs for the purpose of negative publicities or for the purpose of misinformation? And the candidate may lose his election because of such negative EAs. Long hair, there's no need to pay for it. If you want, I can give you 10 such groups. Second, they don't have time. They won't have any time to answer your questions. So perhaps you should exercise some restraint here. All right, I have 2 or 3 more questions, but time is up. Chairman, do give them some time for answers. Well, EA is defined under the ECICO. The statutory definition is very wide. It doesn't depend on any particular form, whether it's on the internet, whether it's Facebook or other social media. If you release certain information that can facilitate the electioneering or the successful election of a candidate. So if you release such information or you assist certain people in releasing the information, you have to be careful. It may be an EA, and if the expenses are not accounted for, you run the risk of violating the ECICO. But how can you to find out who's to blame? Well, everything turns on fact. Freedom of expression is a value treasured by Hong Kong people. On the internet, we have to ascertain whether certain information or speeches might be made for the purpose of positive or negative publicity. So that's not very clear. You cannot say that if something is positive, it's an EA or vice versa. According to the REO, you will send out 80,000 letters to check voters. According to the Mr. Justice Fung, you are going to check 1.6 million voters. Can you account for the difference between the two figures? And what are you going to do in practice? 1.6 million is a big number. Coupled with the another 200,000 that you checked previously, we're talking about half of the voters. On the one hand, we encourage people to register as voters. On the other, you check them through different means. It's not that checking should not be done. There are problems because you send the letters by registered mail. If you don't respond by 2 weeks, your registration can be cancelled.
So there are people like me who have to go to work and I don't have time to go to the post office to collect the letter. Then you cancel the registration and it will cause a lot of trouble. And a lot of people have told me that you ask them to prove their address. Your answer just now said that it may not be so, but you said that if you have doubt about the address, suspecting whether that's the place where that person lives. So actually, people are very annoyed by this, in particular the elderly. They really don't know how to respond. So can you give us an answer in writing, telling us what you will do and how many letters will be sent out, because 1.6 million is really something. And just now, some people have registered because they want to ensure they have the right to vote. However, if at the same time you are trying to verify their voter status, then what will happen to his new registration form? Chairman, please make sure that he's willing to provide us with the paper. Mr. Lee? Of course, no problem. After the meeting, we will give you a reply in writing. And I would also like to answer your questions here. For 1.6 million voters, they are within our scope of coverage. So for this 1.6 million voters, we will check the data. Under the Housing Authority, there are already 1.4 million voters. We will check their addresses and we'll check whether they are still in the record of the HD. So if that is the case, then they will not receive letters from us. Now, some of them may not have sent back the reply slip, or they have not provided information as requested, then we will send out a letter. And this is in line with the law. If after that we do not get a reply, we will put his name under the list of cancelled registration. And as for the registered mail, for the 2 weeks you mentioned, according to the legal procedures, we have to send out a letter in a registered form because it is a serious matter. So after sending out the registered mail, if he receives the letter, we hope the voter can reply as soon as possible. And the deadline is the 2nd of July this year. Unfortunately, if he does not get letter, the post office would leave a collection card behind, and 2 weeks will be given to the voter. If the voter does not go to the post office within 2 weeks, then the letter will be returned to the REO. Now, if the voter still lives at that address, he would definitely receive that card. But after 2 weeks, if he still hasn't received that card, he can call our office. Now we have started registration, and we are calling on people to respond to our letter as early as possible. Otherwise, their name would be put on a list which might have the registration cancelled. But they may make a claim in accordance with the law, and judge will decide as to whether his voter status would be reinstated. And there may be voters who may not be able to reply in time, and at the same time he has sent us a registration form. That doesn't matter, because we just want to update his address. So if he's sending us new information, then definitely we would handle his application. Now, if with the assistance of certain organization, he's filled in a new form and is sent to the REO, then we'll handle it. There will be no problem with his registration. What do you mean by handling? That means we will update his information. If his address is different from his registered address, we will update it. If the address is the same, then there will be no problems. We just want to verify. So we send him a letter. He should send us back a reply slip. That's the same as giving us a new form. But we need objective facts. We may suspect that the registered address is not his major abode, that he would have to prove to us that he continues to live at this address. So we will need to look at the information he sends back to us, and we will find out whether we are satisfied with his answer. Mr. Lang Yu-chung. I remember the last election, many members of the public said that when they went to the polling station, they discovered that their voter status were cancelled and they couldn't vote. I think that's very disappointing, because we are encouraging people to vote and their voter status is actually cancelled. Now, because they think that they have been voters all the time, so they haven't paid attention to the details. So for the registered letter you sent to them, you said that's an appeal mechanism. So for the voter information that you should have their telephone number. So if he cannot receive the mail, how about calling them? This is question number 1. And also for exit poll. Just now you said that the exit poll should not be conducted by candidates or organizations related to them. But we've seen candidates' assistants, and they would be surrounding the people who are doing exit polls, and the exit poll result may be leaked, and this may have an impact on the election result. So for the polling organizations, they may be disguising as academic organizations, but actually they would leak the exit polls to certain parties. So it is very easy for the exit poll results to be leaked out, because there are so many people there. It can be very chaotic. So can you restrict the number of organizations who do exit polls? There shouldn't be too many, and they shouldn't come into contact with a third party. and the polling staff shouldn't carry mobile phones. Otherwise, if they leak the result, you will never find out. So can you have more stringent measures in place? Mr. Lee? With regard to voter registration, before we check with the we will try our best to check with the voters. If they have emails, if they have phone numbers or fax numbers, we will make use of such channels to contact them and help them update their addresses. And if all those fail, we will send them registered letters. And after all these procedures, if we still do not receive information from them, then we will send an ordinary letter to them to remind them that they should reinstate their registration before the deadline. For voter registration, we have an honor system. We want to make it friendly so that it's easy for people to register as voters. But after the 2011 DC election, there were a lot of public concerns about the inaccuracy of the final register. Some voters might have deliberately provided wrong information, and also it's a civil duty for citizens to update their personal information. So we have done a lot of publicity. We hope to raise people's awareness. Now we are checking 1.6 million voters. Actually, in 2012, we also checked 1.6 million. We sent out 290,000 letters. This year, we will not be, we will be sending out about 80,000 letters. So after 2012, 13, 14, that's 3 cycles, voters are now more aware of the importance of the accuracy of voter information. Some people reflected to us saying that it may be too strict because they have to prove their addresses, etc. And this year, we think the situation is more acceptable. And for exit poll, the guidelines have stated that we have to strike a balance. That is whether the election results will be affected. We are also very concerned about that. And we are also very concerned about the order of our polling stations, because such polls will be carried out outside polling stations. But we are also concerned about academic freedom, speech freedom, and press freedom. So for the exit poll guideline, we want to strike a balance among all these. Some people are very concerned as to whether exit poll results will be used to manipulate the polling results. But when we vet the application for doing exit polls, we are already very strict. And we will also limit the number, because you can imagine that our polling stations are not very big. If at the entrances there are dozens of people doing exit polls, then voters will be hindered. So we would appropriately control the number of exit poll staff. The number of staff is very important. Mr. Leung also said that the exit poll staff may have improper communications with agents. So we'll go back and see if further guidelines should be issued. Exit poll staff should not give information to suspicious people. Second round, please, because you have used up your time and then 10 people are waiting in the line. Mr. Sin Chung Kai, Chairman, for these guidelines, Chapter 7, they're about election advertisements, and you have just updated a little bit of things. Just now, several members have asked about social media. I think you really have to explain your guidelines in details, because now there are a lot of problems. For example, if Jamestown is doing his campaign on the streets, and some people may take a photo with Mr. Jamestown and post on his Facebook, and it says that he's so handsome, you should vote for him. And some other people may say that he's from the pro-establishment camp, you should not vote for him. So would this be regarded as election advertisements? This will have a huge impact. We are candidates. Of course, we will try to explain to our election teams as to what should be done and what shouldn't be done. However, people may take photos or videos of candidates and post them on YouTube, so the candidates themselves don't know about that.
If I hand out leaflets on the street, someone take my photo without telling me, I wouldn't know, and then the photo can be uploaded to a Facebook account. So what are you trying to regulate? It seems that you are just amending some words, electronic data and so on and so forth. As you've said, all of these are covered by the reporting obligation. But what about ordinary people? Maybe they have violated the ECICO and you cannot take any enforcement action against them. Many citizens use overseas internet sites. If someone takes a photo and he takes a plane and create a website in another place, you cannot take action against him. It's out of our jurisdiction. Can the EAC add something to Chapter 7, covering social media, and offer some explanations? I believe you did receive many inquiries during the election. I think the information will be sufficient for you to write a book. Why don't you beef up the explanations that you have been offering? Undersecretary, I believe you are also a veteran election campaign organizer. You understand this. Why don't we do something to move ahead with the times? Or perhaps you can talk about FAQs. We're talking about not just a few hundred candidates, but everyone, millions of people who are using social media and smartphones. Mr. Lee, Chapter 7 is on EA, election advertisements. They are guidelines, but the bulk of the guidelines reflect the definition of EA in the ECICO. It's a statutory definition, and as the member has said, it's a very wide definition. If you do something that gives other people the impression that this is for the purpose of securing the election for a candidate, or is negative publicity, it can be an EA, because the format can be very varied and can take many forms. I think in the past, from time to time, our EO staff did give explanations in response to inquiries. We have previously talked to ICAC, so perhaps we can prepare some FAQs to provide further elaborations on what is or is not an EA. But if you just take a photo with a candidate and you post the photo in a social media site, Is that an EA? Well, we cannot adopt a broad brush approach about this. We cannot generalize everything. It must be assessed as to whether the facts support the allegation that this is for the purpose of facilitating the election of a candidate. Well, the latter part of your explanation is something that I would like to get some elaborations on. These pages in the guidelines are not sufficient. If I say someone is nice, please support him, please vote for him, then that's clearly an EA. But I will be talking about something social in nature. I think the ICAC have already got many cases. I think you should provide more information to the candidates and those who are involved in electioneering. All right. You want more information on and elaborations, but I'm afraid that after they have provided more information, it becomes even more unclear. So you check with the Hong Kong Housing Society or Housing Department to see if the voter is a registered tenant, and if it's not, you may cancel the voter registration of that particular person. But I can tell you that there are many people who are living in public housing estates who are not registered tenants. Do you have a mechanism to check that they are actually living there? And also you are going to do something where, in respect of cases where you have doubts, and you ask for proof of residential address. They don't have utility bills registered in their names to prove the address. If they can receive your letter, then they would have the obligation to prove that they are living there, because providing false information is a criminal offense, and if they vote under this basis, it's an even more serious matter. And we are talking about problems faced by elderly people in particular. They don't have any utilities accounts or bills registered in their names. If you ask them to get a JP of a lawyer to prove that, oh, that's a joke. That's a joke. Will a JP be willing to do it? Because JP must know personally that the person is actually living in that address, and it's a criminal offense if some false declaration is made. I've encountered a real case recently. Well, it's a taxi driver. He lives in Samjian. He's a Hong Kong permanent resident. He thinks that as a citizen, he enjoys the right to vote. Can he register the address of a relative? Can his voting right be maintained if he does this? Or of the 1.4 million voters who are living in estates run by housing authority or housing society, well, if they do not respond, if the information shows that they are not living there, then the registration may be cancelled. But they can only what they have to do is to provide a response by returning a completed reply slip we cannot just ignore that those people may not be living there. We must be satisfied that the address is the main address of that voter in Hong Kong. So what I'm trying to say is that even if the information shows that he is not living in that particular address, the registration is not cancelled automatically. And I have to stress that not all of them would be required to produce proof of residential address. There must be some objective basis for doubts to be had. So we would ask these questions and ask for proof of address when we have certain information showing that he or she may not be living in that address. We accept a proof of address of people living with the voter in the case of an elderly voter. And if they don't have any proof, they can just call us. If they live alone, so in such cases of difficulties faced by voters, I urge them to contact us, and we would try to help them. Well, it's not that we try to deregister them. It's done for the purpose to update the information in the registers, because we don't want people to doubt that the information in the registers is not updated or is not complete. Thirdly, on the question of the only and main residential address, that's a requirement in the law. In the case quoted by Mr. Yip, if that person can give us an address, and which is his main address or his main residence in Hong Kong. A person may have a residence in Hong Kong and another residence out of Hong Kong. If that person can prove that the residence claim is the main residence, then it would be acceptable. Well, what if the address is in a public housing estate, and he's not a registered tenant? He may claim that whenever he returns to Hong Kong, he will live there. But if you check the tenant's registration of the housing authority, you won't find the name. And that person will only be living in that address when he or she returns to Hong Kong. In the inquiry process, we ask the voter to confirm that he or she is living in that address in a public housing estate. And if he can produce a proof, we will keep the registration. But if he has moved to the mainland, he doesn't have any documentation to prove his address here in Hong Kong. But according to what you have said, if that person lives in that particular address once he or she returns to Hong Kong, how can he or she get the proof? Well, there must be some connection between that person and those people living in the address. If those people living in that address can provide, say, a declaration that this person is living with us, then that would be accepted by the REA. Mr. Wu Chi-wai, I have a follow-up question on some of the questions. If the voter says there's no need to update any information, but the voter has no proof to show that he lives in that particular address, is that a violation of the law? According to Mr. Lee, if you confirm that you have received the letter and claim and confirms that he is living there, would that be a violation of the law? And now we have no canvassing areas, but how they are drawn up are not subject to clear and specific rules. Can you tell us how those rules are drawn up so that we know how to comply? So we don't have a situation whereby half of a block facing the polling station would be designated as no canvassing area, but the other half of the block is not. In non-public housing estates, premises not owned by the government, if candidates are allowed to do electioneering, of course the fair and equal treatment principle should apply. For private buildings, you have to make sure that the owners' corporation or the management companies will comply with this principle. And if they don't, you can reprimand them. When is that going to happen? If the reprimand is given after the 7-week electioneering period, then that's not very useful. So I think we should make sure that everyone follows the same set of rules.
Mr. Lee, when it comes to voter registration, the law states that a voter must have a major address. So we have to rely on the voter to prove that is his major and sole address. So he should have a certain connection with the address. That is, for example, he actually lives there. So I think sometimes we have to trust the statements made by the voter because this is an honor system. And for the no canvassing area, according to the law, the electoral officer can make the decision of the boundary. And he would look at the rows outside the polling station and make a decision. But of course, he would have to look at the geography of that place. And he would also look at the routes through which the voters take. If some of the routes are wider, then the no canvassing area may not be that big. But if those roads are constricted, then we hope that voters can have an easy access to the polling stations, so the no canvassing zones may be wider. In the past, people have told us that some of these no canvassing zones may be too big. So after the last election, we have decided with the returning officer, we hope that the no canvassing zones can be delineated in an appropriate manner. As for private premises, well, according to the guidelines, we have to treat the candidates in a fair and just manner. And in the course of investigation, we really have to look at the progress of the investigation. We have to be very careful. Even though there are complaints, we have to listen to both sides and see if we should take follow-up actions. The EAC is very concerned about this. At the last general election, there was a complaint made a few days before the polling day. We thought it was quite serious, so within 2 to 3 days' time we handled it. And before the polling day, we openly reprimanded the private building organization. So we would have to look at the seriousness of the matter. Because of natural justice, we have to listen to both parties. Well, some complaints are about electioneering activities in private housing estates. So we really have to listen to all the stakeholders before we can decide on whether certain candidates have been treated unfairly. Mr. Ng. Well, for electoral guidelines and laws, I have some questions for the government. With the relevant guidelines and laws, what's the number of the candidates that have violated such guidelines, and what's the percentage? Hong Kong is a place with the rule of law. We need to have appropriate rules and guidelines when it comes to elections. This is good. However, if rules and guidelines are too strict, then they are not good guidelines. It is said that AOs, directorate grade staff and police officers, as well as information officers, they should not openly support any candidate because there may be conflict of interest. However, in Hong Kong, we have a declaration of interest system, including the Legislative Council. There are tens of thousands of police officers, and for information officers, a lot of companies may have information officers. They may not call themselves information officers, but they are doing the jobs of information officers, and there are a lot of people in the press, and they may be playing certain roles during an election. They may be the moderators of certain talk shows, etc. So they may have certain political inclination. Would there be conflicts of interest as well? Have we taken reference from other countries' standards? For example, have we looked at the American standards? Shouldn't we base our guidelines on certain standards? Westerners may have their own rules and Easterners may also have their own rules. At the next stage, should we conduct a study? Well, a lot of people are involved, and the ICAC would also have to spend a lot of money and resources on this. With regard to your first question, if I understand you correctly, you asked how many candidates have violated the guidelines. How about the ICAC cases? How about court cases? They should also be included. We are talking about the guidelines. For ICAC, I think you are talking about the ECICO. I do not have the figure with me. I wonder if the ICAC can give you the figure. If Mr. Has such a question, I can relay your question to the ICAC. As for candidates violating the guidelines, in the last cycle, no candidates has been confirmed that they violated the guidelines. As for restrictions on civil servants, I want to clarify that for Chapter 7, we are talking about CSB rules, not EAC rules. Mr. Has several concerns, and your concerns will be reflected to the CSB, and they will review as to what ranks in those grades should be governed. Ms. Claudia Mo. For EAs, this is a huge issue. Political advertisements is a huge issue. It is very difficult to define. You have to look at the content. So what are you going to do? You cannot ask the police to monitor this for you. They do not have enough manpower. So will you be setting up a team of media police? But there are numerous DC election candidates. So what's the actual operation? And I would like to follow up on Mr. Ray Chan's question about exit poll. We are saying that if some polling organizations violate the rules, they would have to bear criminal liability. However, when I looked at the guidelines, you would just reprimand them. It's not a criminal offense. You may just make public the organization's name. For example, if I am the chief reporter of a newspaper, I'm not asking my reporters to do exit poll. I just ask the reporter to interview several hundred voters and report on their answers. How do you count this? This is press freedom. You shouldn't hinder it. But they are actually doing some sort of polling. Mr. Lee? For election advertisements, we now have set out clear guidelines. We will. Well, I would like to clarify. You mean you would receive complaints? That means you are passive. You receive complaints and then you will act accordingly. You won't be monitoring proactively. So when we receive complaints, we will follow up. And of course, we will monitor the whole election process. But many voters and constituencies are involved, so it's impossible for us to monitor all the candidates and electioneering activities. So after receiving a complaint, we will follow up immediately. And actually, the candidates would monitor among themselves. The public would also be monitoring the candidates. We hope that we can ensure that the relevant electoral rules and guidelines are followed. As for exit polls, there are now application and vetting procedures. Now, we do not want to undermine the fairness of election. However, we want to respect press freedom and academic freedom as well. So there is a certain degree of freedom. We would not be stopping any reporters from doing the work. However, we have to maintain order at our polling stations, and there are no canvassing areas. If any activities within those areas affects the order, we will intervene. But I asked about criminal liability and reprimand. As for reprimand, we will immediately follow up on that. If we discover that an exit poll organization does not follow our rules, the EAC will look at that, and if there is a need, the organization will be reprimanded. And when the organization makes the application, he would have to sign an undertaking. If he violates the conditions in the undertaking, we will follow up with the Department of Justice, and we will follow up in terms of legal actions. Well, there are still 6 members who would like to ask questions, and we will have to hand over this room to the next meeting at 4:30, so I cannot extend this meeting. So there will not be another round of questions. So after the 6 members ask their questions, we will see if members want to ask other questions concerning item 4, because they are also about district council elections, and they are the practical arrangements. Maybe you have already asked the relevant questions. Ms. An Chang, Thank you, Chairman. Just now, Ms. Claudia Mo asked about EAs. And I remember that at a certain election, I went to Hong Kong. When I went to that street, it was filled with Claudia Mo's banners. I remember it was purple. They were purple in color. I was so scared. So no matter whether it's DC elections or electoral elections, you will see scenes like that. Sort of flags and banners line the whole streets. And I say, where can I put my banners? They say that you can put your banners in the next street. I say that this street is busier. How about tearing down some of her banners? The people say that you cannot touch them. So I called up the relevant authority. And then the officers came. They said that you cannot tear it down because there are people guarding these banners. Well, if I cannot do that, then next time I'll do it earlier. There are a lot of corners. Maybe I should go to those places at 6 a.m. and occupy those places so that I can put my banners there. So I think all this have to be clarified. Now you have people guarding the banners. Then you can have all those banners. You can have the whole street to your own. So, Mr. Lee, I think in the future, you really have to tell the aspirers more clearly. Otherwise, there will be a lot of litigations. And Mr. Lee, I would like to ask you a question. Our long chair and Claudia Mo are talking, and I am speaking.
咁咧就即係好多人嚟嗰啲地方咧，人哋咧就登記咗選民之後，譬如話。
So it's okay if I live in a certain district and I can vote in that constituency. But if a person has moved to another place, then he or she may not be able to update the information every time. So we have to get with understanding. We have to get an understanding on the reason behind the need to register the address. First on EA. Non-complying EAs. In major elections, all the locations for displaying EAs are allocated by the returning officer. So unless you have get the consent or approval, relevant approval, then you cannot display the EA. Whether someone is there to watch over the EA materials is irrelevant. In the past, there were violations, so we will be talking to the returning officer to see how we can be more effective in enforcement, so as to properly manage the situation. On the second question, a voter has to register his address. In the November DC election, we have 431 constituencies. So we have to allocate the constituencies based on address of voters. We have to allocate a certain polling station for voter. Well, if he used to live in Wan Chai, well, why don't you allow him to go to Wan Chai to vote? You have expended so much manpower in doing this. I just don't feel comfortable about it. I have a question. You will send people a letter and you ask them to reply in 2 weeks, and that is to show proof of address. Can the voter call a hotline for confirmation purposes? Do you provide for this? Can they confirm this by giving you the first phone number of his ID number? Would there be any technical difficulties if you are to do this? Let me clarify that the 2 week is not the reply time deadline. They have to do this by the 2nd of July this year. If the voter is not sure whether he can vote in the next election, can he seek confirmation from you? That must be done in writing. We need the signature of the voter. What's the purpose of doing the confirmation in writing? Under the law, it carries certain significance. The voter must sign the document, and it carries certain criminal liability if it's not done. It's not right. Well, it can be done through a telephone call, because telephone deals can involve millions of dollars in investment. We cannot accept telephone calls. We need to ascertain that is from the voter. Can you amend the law? We need innovation. We need IT. People are managing their financial affairs on the internet or over the phone, because you are wasting paper. Or you can give them passwords. CY Leung has been talking about the need to have the IT bureau. Let's apply IT and innovation to this field first. I think the system is already very well established. Please remember this. And also you can keep records of phone calls. And the next question. And it's about the internet. It's a perennial problem. If someone says long hair is against the CPG, is this for or against me? Because someone will vote for me on hearing this. If Obama says CY is shit, what would happen? Someone in the U.S., Obama or other people, saying this. First is they are not in our jurisdiction, and also, or say Xi Jinping says CY is a shit, then he's done. Because I'm concerned that people may scold me, and I'm responsible for that expense. Dr. Helena Wong, I'm also concerned about social media. And the guidelines to regulate such activities during the electioneering period. If someone upload a photo saying that he supports Mr. James Tin, and someone share the page, then there's a problem. You cannot ask people to stop sharing things on the internet during the electioneering period. That's not possible. And so the guidelines are not clear about social media. Facebook, YouTube, Twitter, email, Line, WeChat, WhatsApps. Many people are using this. And of course, during the electioneering period, many people will be caught unaware. The government should come up with clear guidelines. in Europe, in the US, Japan, Australia, New Zealand, and so on and so forth, where there are democratic elections, then they use social media a lot. I've just checked the situation with New Zealand. They have certain exceptions, and they have social media election laws. Chairman, can we ask our research division, either the REO or our own secretariat staff should carry out a study on how the electioneering activities are regulated in respect of social media applications. In New Zealand, the rule said if you are not a campaign worker, if you're not a candidate, and you express your views through social media, as long as there's no money involved, you don't receive money, you don't pay anyone money, then it's not an EA. You cannot say that if you share something or you like something, you are caught. It's just not possible. So you must tell people what is not allowed. There are existing rules and regulations in other jurisdictions that we can make reference to. So, Chairman, next time perhaps we can get all the necessary information to see to facilitate a discussion on how we can make use of social media fairly, so that we don't have a situation whereby those who are daring would use the social media for conducting such activities, but some are not bold enough to use them, and we'll be regulating people and activities that we shouldn't be regulating. And I cannot put a marker on the internet that you should not share this. Or during the electioneering period, should we ask everyone not to support or any candidate or to criticize any candidate? I think as long as there's no money involved, you should not regulate this. This is just not realistic. Let me provide a response. Different jurisdictions have different electoral laws. And as I've said, the definition that we're talking about is under the ECICO. We're talking about behavior. A behavior will not be excluded just because no money is involved. We don't have such rules, but other jurisdictions have. Well, if necessary, if we need to explore the legislative amendments, of course, we can bring up the relevant subjects for discussion. But at this stage, there's no exemption in the law. So there's a possibility that if people do that, it will be a violation of the law. As for the need to elaborate the guidelines, we'll talk to the ICAC to see if more can be done. For every election, the ICAC will prepare a set of guidelines on the relevant provisions and how they are under the ECICO and how they are interpreted. So we provide more information, clearer guidelines to candidates and related and relevant people. It will be a direction of duty if the REO doesn't conduct a research into other jurisdictions. In that case, perhaps the chairman, you should ask our research staff in the secretariat to do it for the next meeting. Well, I can talk to the research division of the secretariat, but they may not be able to do it in the time frame allowed because they do have a heavy workload. That may not provide an immediate solution for the coming election. Ms. Priscilla Leung. Well, our laws do not encourage people to stand as candidates. Well, a friend of mine did not get any written consent from his supporters. He ended up with spending $2 million and a court case I can see a lot of pitfalls. So the best course of action is to do nothing. And now you don't encourage people to vote either. Members have been referring to the letter you send to voters. Even for the clever young people, you have to read it very carefully before you know how to comply. It's a nuisance. It's a lot of trouble for many people. People won't take the trouble to respond to your letter. It's a joke to ask a JP to do the confirmation. Some people got registered decades ago, and now if they fail to respond to your inquiry letter, their electoral or voting right will be taken away. It's a fundamental right. The person may be suffering from poor eyesight. He might have moved to another address. So it's not fair, and many political parties suffered. You have asked more than 100,000 people about this. Do we have 1.6 million voters with problematic addresses? If many people are disqualified, you'll be sued. If they forget to reply, they won't have the right to vote. And you know that the letter is written in small print. Well, you must prove that the person is not living in the claimed address. You have to do it.
They have to investigate. Now, if that person really lives there and you revoke his registration, then there will be a problem. If he has moved away, then that's another issue. And you are saying that there are 3 months. So in July, August, and September, you are asking people not to move. And also, for Hong Kongers who are living on the mainland, can you tell us in writing that they have to pay tax in Hong Kong, but they do not have the right to vote here? You dare not say that. They have the responsibility to pay tax, but they do not have the right to vote. But this is a very basic constitutional right. You have never faced this squarely. I have been talking about it for 2 years. This is a major problem. I have asked Justice Fong, and he says that he cannot give me a clear answer. You should go to the courts. And who can afford to pay the court cost of over $2 million? And now you are creating troubles. You have to stop it. You have to review. Are you really going to send out that 1 million odd letters? He has already explained just now. But this is your opinion. I think, Mr. Lee, you do not have time to answer the question. Mr. Paul Chair. Chairman, now this is a consultation. But when it's not an election year, they are not doing anything. And now they just have 1 month consultation period. But would you change anything after the consultation? You've heard a lot of views from us today. There are very important points. But I don't think you can do anything to change it. And policy-wise, you won't change it. Every cycle is like this. After an election, you won't do anything. And then in the election year, you say it's too rushed and you cannot do anything. Miss Priscilla Leung was very concerned about a lot of things, and also other members asked a number of questions. So it seems that there are a lot of obstacles if people want to vote. Chairman, I want to look at this from another perspective. Mr. Lee says that 1.43 million voters are living in public housing. And if you think there is a query, then you would check their addresses. I think you are discriminating against PLH tenants. Why don't you check those people living in private buildings? According to Cap 177A, for all people holding Hong Kong IDs, they have to declare their addresses. Otherwise, they are subject to level 3 fines. So when you have to enforce the law, you don't enforce it. And now you are discriminating against PLH tenants. Are you targeting them? And if you find out discrepancies in addresses, then you will disqualify them. This is not right. For PLH tenants, most of them do not have high educational levels or qualifications, and it is very unfair for you to target such a vulnerable group. And are you helping the housing department to find out whether there are illegitimate tenants? Because you will make the tenants worried. If he is not on the PLH register, and if it's found out that his address is there, then would he get himself into trouble? I think this is highly unfair to the PLH tenants. I think you should stop it. Otherwise, you will be hurting a lot of people. How many people are you talking about? 800,000? There will be a lot of people in each district that will be affected. And it will be very unfair for a lot of districts, and there will be numerous petitions. I have a question for you. You are saying that now there is a claim mechanism. Paragraph 2.16 of the consultation paper, you say that after the deadline, the case will be referred to adjudicators. Who are they? And shouldn't the rights be given back to the voters? Who are those adjudicators? They are members of magistracies. Are they, if they are revising officers, are they magistrates? The judiciary will nominate these people. Who are they in the judiciary? They are magistrates. So why don't you tell us clearly that they are magistrates? Well, they are named as revising officers in the relevant law. So why don't you just tell us very clearly that they are magistrates in magistracies? Why do you have to make yourself so ambiguous? Because this is a very important constitutional role. Why don't you tell us who these people are? Yes, I understand the members' view. Maybe we can clarify this in the guidelines. Mr. Kwokake, you have been coming in and going out, and it was your turn just now. But now we just have limited time left, 4 minutes for you. Because we still have another agenda item. Now for the guidelines, I think there are a lot of loopholes. Mr. Lee has heard a lot of views today. Now, in September, you will be issuing this set of guidelines, and there are still so many loopholes. When will you come back with the revised guidelines? This is number one. And second, about social media and internet. I'm surprised to hear that the government doesn't know. In the past two elections or in overseas elections, for example, in the 2012 U.S. elections, you could already see that internet was a very popular platform. If the government doesn't have any view on this, I'm very disappointed. I agree. That is an election advertisement, but we are now arguing about costs. Because Well, many candidates would use social media, and it costs you nothing. You can use Facebook, you can use other social media. You don't have to spend any money on it unless you are putting an advertisement there. And if you place an advertisement there, the advertising company would know, and that would be a problem. So in the future, if there are disputes about this, it will be unfair to certain candidates, especially those candidates who do not have a lot of means. Now many young people want to run in elections, and they cannot compete with political parties. So the only means they can use is social platforms. So if you want to nurture a new generation of political talents, you should give them this opportunity. And I would like to ask about exit polls. Now, many exit polls are manipulated, and they are used for affecting election results. Many of them would ask similar questions. So can the government coordinate so that only one organization will be doing the exit poll? And if we look at overseas practices, they have a station in a secure zone outside a polling station, and they will just ask the voters to fill in questionnaire. It's not like now when you exit the polling station, you are surrounded by people. You don't know who they are. So do you want police officers to be all over the polling stations? Well, we need a more civilized way of doing it. Voters should have a choice as to whether they want to take part in the exit poll. Mr. Lee? I'll answer questions concerning the exit poll. I didn't say the exit poll would be used to affect election results. And now the exit polls are very transparent. If we approve certain body to do exit poll, the results will be put on our websites, and also the information will be posted outside the polling stations, including names of the polling staff. And also these polling staff would have to put on a name tag so as to tell people that they are working for the exit poll. And before they carry out the exit poll, they would have to tell the voters that what kind of polling they are doing. This is not run by the government, and voters can choose as to whether they answer or not. Well, I have my own personal experience. They did not read out that passage. So how are you going to control them? Do you have any undercover that will try to find out what's actually happening? Do you have any undercover operation? Have you asked the exit poll staff whether they follow your guidelines strictly? In the coming election, we will remind all the presiding officers to pay attention to this. That means you haven't done anything in the past. So exit poll, you can choose whether you will answer or not. There's another agenda item. Item 4, practical arrangements for the 2015 District Council election. Now, the time for this meeting is up. Shall we discuss this item at the next meeting? Can we lengthen our next meeting a bit? Can we hold a special meeting for this? Let me ask the government first. Is it very urgent? If we can wait till the next meeting, then we'll discuss it at the next meeting. I would like to ask Mr. Lee to tell you the answer. For the DC ordinary election is fixed on the 22nd of November. The EAC is now going to finalize the measures, and these practical arrangements are to be implemented. So timing is very important. After May, we have to launch the arrangements one by one, including voter registration, recruiting of polling station staff, etc. So we have to do this as fast as possible. I think for voter registration, we have expressed a lot of views already today. So for the practical arrangements, be members still have some other opinions. You are saying that you will launch them very soon, so maybe those opinions won't affect you. Well, we can discuss this on the 15th of June. That's the next meeting. If timing-wise you think that is okay, because the ordinary election will be held in November. These are just arrangements. These are not laws. Then we can discuss it on the 15th of June. If you think it is urgent, we cannot wait till June. Then we can look for a time to hold a special meeting, because now it's very difficult for us to add meetings. We only have Mondays and Tuesdays every week for meetings. Yes, on the 15th of June, we will listen to members' views. But there are some practical arrangements, and we have to do them now. Actually, we are now already recruiting staff. I don't think anybody is going to stop you from doing that. But for voter registration, a lot of members think that you are creating too much trouble. And some members of the public may think it's too troublesome, and so they won't vote. Under Secretary? Yes, we will continue to do our work. And this item can be discussed at the next meeting. Yes, on the 15th of June, we can prolong our meeting by 1 hour. Actually, the two items today are closely related to each other. They are just a bit different.
I think that's all the time we have today. We have to hand over the venue, the AOB. You want to say something? No. We have not agreed that they can continue with what they are doing. Recruitment, they're recruiting staff. Are they doing those things that are causing troubles? No. I don't think we should make it clear that we give them no mandate as such. Oh, meeting's adjourned.